Thank you.
SJC-11072, White versus Colbert.
Good morning, and may it please the Court. This case involves the rights to a 2-mile beach on Martha's Vineyard that has been shared for generations by the Norton and the Flynn families. We have two contentions on appeal. The first is that the Nortons have a non-exclusive shared ownership right to the western half of the beach that is based on deeds going back to the 1700s. As the land court recognized in this very case, grantors can grant a fee interest with a movable boundary as long as they also own the adjacent property into which the interest can move. And that is exactly what the Nortons grantors did when they conveyed a beach, either without mentioning a northern boundary at all or by referring to a boundary of natural features like arable land or ponds.
So it's a movable beach that over a period of decades could move from one location to another.
It could move northward or southward. There is no contention that there is an easterly or westerly boundary that could move because the deeds consistently define the western boundary as either the Oyster-Watcha opening or the Watcha line, which is known, the eastern boundary as Job's Neck Point. The southern boundary is the Atlantic Ocean. There's no dispute that that can move. And the issue in dispute here is, Chief Justice Ireland, whether the northern boundary is movable because it was either not defined at all or defined as arable land or ponds, which move, it's undisputed, and were known to move as the beach moved north or south.
What do you, does it matter to you that the other 1841 deed, that is the one that switched Wilmot's, that interest, has a fence named in the deed?
It talks about the fence or beach as the southern boundary of the Pahogganett.
Is that the edge of the beach? Doesn't it say that?
It says westerly by the fence or beach, and that defines the southern end of the Pahogganett upland parcel. That's correct. That is what it says. Our position is fence or beach recognizes that the beach was moving and could overtake the fence, and at such point where the fence no longer was there, the southern boundary of the land would be the beach. But the point is that is an upland deed, and it has to be viewed in the context of the entire transaction, not only the one that was going on in 1841.
Wilmot didn't own the entire breadth of the beach on the northern boundary, did he?
That's correct. Our contention is only as to the Paqua and Pahogganett areas, and he did own interests in both Paqua and Pahogganett. That's the western half of the beach. And in 1841, what the Smith family was trying to do was reallocate the interests in both the upland and the beach so that Wilmot would wind up with only the Pahogganett upland, and the nephews would hold the entirety of the beach and Paqua. According to the land court's decision and the appellee's position, they failed to do that because ultimately the beach would have receded into Wilmot's land in Pahogganett and he would have wound up owning the beach anyway. In 1888, when Allen Norton, who owned an interest in both the Paqua upland and the beach, conveyed away Paqua to Edmund Beadle, keeping the beach for himself, according to the land court and the appellee's position, that would mean that Allen Norton kept for himself an interest that was going to vanish in a period of years.
In terms of other decisions that you cite as having movable boundaries, they seem to me, and I haven't studied this hugely, but they did seem to me to be ones in which they involved either the land between low water and high water mark or something that related to whether it's gathering oysters or seaweed, something that relates to the fact that the water is going to be moving. And why isn't this more like the cleared land in the LaRusso case?
The cleared land in Marvell versus Regenius?
I'm sorry, Marvell.
I mean, I can address LaRusso as well. I mean, the cleared land in Marvell, that was not a question of whether the boundary moved at all. There it was a question of ambiguity. The auditor in that case had decided clear land was so ambiguous that he would substitute another line. And this court said no, cleared land was not sufficiently ambiguous to permit him to do that. It was possible.
Related issues?
No, I don't submit that they are. I mean, I think that what happens here is the intent of the grantor, and what was it that the grantor was intending to convey. In Marvell, this court concluded it was clear that he intended to convey, Lucier, I think was his name, that he intended to convey the cleared land as it stood at a particular time. Here, there is significant evidence that that is not what the grantors intended to do. I think there are 3 points that make that very clear. The first is that it was known that the beach was moving at the time, and I don't think that's disputed. There's evidence in the record that in the 1700s, it was possible to skate from this property all the way into Edgartown because all the ponds were connected. But by the end of the 1800s, the beach had moved northward and cut off most of the ponds, Paqua Pond, Little Job's Neck, and Job's Neck Pond, so it's no longer possible to skate all the way over. That means that at the very moment, that at the very time that these deeds were being executed, the grantors knew that the beach was moving northward. The second point, I'm sorry, Justice Botsford.
No, that's okay.
I didn't mean to interrupt. The second point is that that is consistent with the intent of the transactions to reallocate the land in this way.
Well, but if we don't agree with you on that point, and we conclude that, no, the intention of the parties was actually to convey a parcel of land by meets and bounds, and that the fence was a determinative boundary, it was a fixed boundary, that ends the case, doesn't it?
Well,
except for at least with respect to the deeds.
With respect to the deed, if the court concludes that this was a fixed boundary, that's the end of the ownership claim. We, of course, have the prescriptive easement claim as to the entire beach. But just and not to fight the hypothetical, but on the issue of the fence, that comes up in a deed that does not actually convey the beach. All the beach deeds themselves define the beach either as a natural feature on its own without any northern boundary or bordered only by other natural features that move as the beach moved, and that was something that was known at the time. And Judge Trombley actually makes a finding. I'm sorry, again, Justice Botsford.
No, I shouldn't have interrupted you. You go ahead.
Judge Trombley made a finding as to what beach meant in the context of these deeds. He says, and this is on addendum page 18 of the addendum to our blue brief, that the Nortons' predecessors, quote, believed they owned and were conveying a beach, a parcel of land covered with sand and abutting the water. And he also says that these predecessors believed that the location of the parcel was obvious. And when you,
but his finding is really subject to de novo review, isn't it? It's not a finding to which we owe deference.
this court's review of summary judgment is de novo. That's right. And the ownership issue was decided on summary judgment.
Mr. Johnson, do you agree that the location of the beach as it was defined in 1841 is now submerged in the Atlantic Ocean?
Chief Justice Ireland, I would not, as it was defined. Our position is that the definition of the beach throughout all of these deeds is one that has a movable northern boundary, which is the line between the sand and the arable land, that is the land that's capable of being farmed, and that is a movable line. It can move northward, it can move southward, that's where the property line is. If this court concludes that the beach parcel was fixed in time, even though the grantors did not use meets and bounds, they didn't define it as a particular period of time or as a particular fixed feature. But if the court nonetheless concludes that it's fixed in time, I agree that the place that the beach now occupies was not the area that was occupied in 1841. We don't dispute that at all.
Mr. Fleming, I want to explore what I understood to have been something of a concession in the very first sentence that you expressed, in this sense, that the northerly boundary could go north or south. They could migrate north or south. If over the last 200 years the ocean currents were such that the beach actually went southward, would the beach actually grew in depth in the sense that, I don't know how deep the beach is, 100 feet, 200 feet, but if it grew to 800 feet, just a sand out between the ocean and the arable land, if that stayed the same, would the beach deed include only the 100 feet of width, or would it include the entire 800 feet of width that may have appreciated over time?
I certainly didn't mean to concede anything by the point. I think, Justice Spina, the answer to your question is the line of the northern line of the deed is the line between the sand and the arable land. So in your hypothetical, I think that line, wherever it would be the northern boundary of the deeded property. I think what would more likely happen, the geological evidence in the case indicates that the beach has moved generally in about the same way. It's the same sand. It now sits on top of arable land. Mm-hmm. If it were to move southerly, I think the equally likely situation would be that more arable land would be uncovered.
But it might not be. if it moves southerly, you might end up with a beach that is far more extensive than what currently exists. On the other hand, there may be, because of the ocean currents, conceivably, a buildup such that the arable land actually moved southward with the shoreline itself. I mean, it could move in that direction. And I'm wondering if, as the arable land moves southward, you would not have ownership of that arable land?
No, of course not. Okay. No, as the arable land moves south, we have the risks and the burdens of the movable boundary, as do the landowners of the arable land. That said, even when the beach moves northward, the Pahognet parties do not lose the ability to use the beach. We are only seeking co-ownership, which is how the landowners have proceeded throughout the course of this relationship for decades. So this isn't a situation where the plaintiff is trying to expel another landowner from the beach.
Counsel, what significance, if any, do you attach to the Pearlstein opinion letter?
We attach significant significance to it with respect to the claim of right for purposes of prescriptive easement. And I'm happy to turn to that if that's what the Court would like to talk about. Absolutely. The issue on prescriptive easement that Judge Trombley found there was permission on the part of the Flynns to the Nortons to use the beach throughout the time, dating back to the record shows the 1920s. The Nortons were using the beach at that time. The Nortons used the beach under the quite justified belief, justified by, among other things, the Pearlstein opinion, Chief Justice Ireland, that they owned it, and that shows that their use was adverse, it was hostile, it was under a claim of right, all the terms that this Court in Totman versus Malloy said show adversity for purposes of a claim of prescriptive easement. Now, Judge Trombley made a finding that they would, quote, contact Uncle George Flynn, and request permission to use the beach. And there is no citation for that in the opinion, and the appellees have not provided any evidence whatsoever suggesting that any Norton ever contacted Uncle George, or any other Flynn for that matter, before the land was posted in 1999 for permission to use the beach. It's simply not there.
No, go ahead.
Your claim on the prescriptive easement is the beach. The paths to the beach, does it relate to that as well?
It does not. We no longer pursue that. The beach is reachable by boat from my client's properties on Oyster Pond. So we do not claim the roads. We do not claim any upland. And that's important, Justice Botsford, because
wasn't the permission issue about picnicking near the house or something? I mean, was there some evidence?
It primarily had to do with the roads and the upland when one is driving on near the Red Gate or Oyster Watcha or Swan Neck and all the passages that the Kohlberg parties, it's only the Kohlberg parties because the Pahognet parties don't mount any argument on this basis. The Kohlberg parties only cite discussions with respect to driving across the upland to go hunting or something like that. And that's not before this Court. There is nothing in the record. I urge the Court to read the citations that the Kohlberg parties have for this proposition in the brief. They all refer either to the property in general, and Alan Norton is very clear on page 3119 of the appendix that when he says he has permission to use the Flynn property, he does not mean the beach because he owns an interest in the beach. And that was not only his belief, but also the Flynn's belief. John Flynn testified repeatedly at trial that he knew that Sonny Norton claimed an ownership interest in the beach. His father told him that. His two uncles, including Uncle George, told him that.
There was a statement in one of the briefs, one of the opposing briefs, if I remember it correctly, to the effect that the Pearlstein letter of 1950, the opinion letter of 1950, that was addressed to George Flynn and Sonny Norton, that at that point in time, neither George Flynn nor Sonny Norton had an ownership interest in the property. What do you say about that?
Well, the Pearlstein opinion makes, I mean, we're only talking about a claim of right. So whether they actually own the property or not does not matter. The point is Sonny Norton, in the use throughout, going back to the 20s, even when we're talking about Frank L. Norton, Sonny's father, they were using it under a claim of right based on the 1888 deed from Alan Norton to Beetle, which reserved the beach for the Nortons. Whether people knew about, whether the Flynns knew about, or what credence they gave to the Pearlstein opinion ultimately is of no importance. That said, there is testimony at trial
But did Sonny Norton and did either Sonny Norton or George Flynn have an ownership interest in the property at issue?
As of 1950, I don't believe so. I think it happened later on. But ultimately it's of no significance because the use was under a claim of right. I believe what Sonny Norton may have in 1950. I can follow up with the court on that. But it's most certainly the use going back to Frank Norton's use in the 20s, the McCagg's use, their tenants in the 1930s, Alan Norton's use from 1941 all the way to the present day is clear that they used the entire beach, going back and forth by buggy, going duck hunting, not just in the summer, not just in the circumstances where this court found a prescriptive easement in Ivins Nispel or in La Bounty where it was seasonal use just for swimming. Here we are talking about consistent use that was known and acknowledged by the Flynns.
It mattered for your claim that, at least according to Judge Trombley, at least by 1938, the portion of the beach that was the subject of the deed was submerged. Does that matter in terms of the prescriptive easement, that what was the beach wasn't the same as what started out as the beach?
It does not, Justice Botsford, and our authority for that is Phillips versus Rhodes, where this court held that an easement, there it was an easement to collect seaweed, but there's no reason it would be different in the case of a prescriptive easement here, would travel with the land, particularly where, as there, the parties all knew about the shifting nature of the beach. So no, we don't think. I think we can take any 20-year period from the 20s to 1999 when the land was posted, and you can easily find 20 years of open, notorious, continuous, acknowledged adverse use by the Norton family. So at the very least, we think that the judgment of the land court should be reversed on that basis.
Counsel will have to leave it there. Thank you very much.
Thank you, Mr. Chief Justice.
Good morning, Your Honors. My name is Brian Hurley, and I represent the Hartigan Trust, as well as Michael Myro, who's the trustee of 3 trusts that purchased land from the Hartigan Trust in the year 2001. I think I was going to give a certain argument, but I think I'll take my cue from the questions that were asked by the bench this morning. I think clearly the most important issue that's before you is this concept of a movable beach. Quite frankly, I don't think the prescriptive easement issue rises to the level of review by this court.
You mean because it's so clear that there isn't one?
I think that's the case, Your Honor, because the one thing that's omitted from the discussion of Judge Trombley's decision is the fact that he found, leave aside the question of permission, which may present an interesting issue, he found that there was no evidence to support a finding of open, notorious, continuous use of a particular area for a 20-year period. You have to read it carefully to find that, but it's in the decision. He made that finding.
But I think Mr. Fleming is saying that that's an erroneous finding. It's not based on the evidence, that the evidence clearly indicates the contrary.
Your Honor, if you go through the entire transcript, and my focus, frankly, is on the record title issue, and Mr. Pusilowski was going to focus on prescription, but if you go through the record, it is replete with instances of permissive character of the use. It starts, frankly, on the very first day of the trial. And keep in mind, this was a 12-day trial, 400 exhibits, an extensive view taken by the court to fully appreciate the magnitude of this property and the scope of this beach.
How did the judge get out there, by the way?
I'm sorry?
How did the judge get out to the view?
We took him in an entourage out to the beach one day, and it was a fascinating trip. But in any event, he had that opportunity to see that full breadth of the beach and to appreciate the relative distances between various points on the beach. And based on that determination, he found, and clearly, Judge Botsford, I agree, that wasn't the principal basis of his decision, but he did find that there was insufficient evidence on those points. And I think if you cull through that entire record, you will conclude that he wasn't clearly erroneous in reaching that conclusion. But on the evidence of permission, I disagree with Mr. Fleming, respectfully, that there was any evidence to suggest prior to the latter part of the 1970s, prior to the death of Sonny Norton in 1981, prior to the arrival of Mr. Friedman on the scene in 1983, that there was any evidence to suggest that the Flynns would have operated under the apprehension that the Nortons were there under any claim of right. There was simply no evidence that before the latter part of the 1970s that anybody in the Flynn family, other than George Flynn, who at that point was the sole remaining life tenant in the Hartigan Trust ownership, that anyone knew about that other than him. And I think the evidence would support a finding, rather, if you look at all the evidence, is that what happened is in the end of the 1970s, when Sonny Norton decided that he needed to clear up his estate affairs, it was only at that point that the Pearlstein letter was resurrected and then brought to life after Mr. Friedman bought the property in 1983. And clearly, I can see to you...
Wasn't the letter addressed to to your predecessors?
It was addressed to George D. Flynn Jr., who was at that point the sole life tenant. Well, actually, he wasn't the sole. He wasn't even an owner at that point. It was before Elizabeth D. Flynn died in 1951. He was just a person in the Flynn family, a friend of Sonny Norton's, and for what reason they sought to have that letter, I don't know. But the answer is, to your specific question, is neither owned property, the property at Hartigan at that point in time. And indeed, when Sonny Norton's mother died in 1951, she didn't even list the beach in her probate inventory. So she clearly wasn't operating under the assumption in 1951 that they had any claim of right to the beach. So I think on balance, if you read all of the testimony, and as obviously Judge Tremblay had the opportunity, the unique opportunity to do, and to assess the credibility of those witnesses, I think his finding that this was permissive was not clearly erroneous. He didn't impose a standard of hostility proof. He simply said, I find this is permissive. And so there's no legal issues involved, I think, in this aspect of the case. With respect to the record title issue, my suggestion to the court is that if you look at all the evidence, notwithstanding the assertion that it was so clear what the intent of the party was to the contrary, it was clear by that division, which was complicated, and it's set out in great detail in the affidavits of Eric Peters, who was our title person, and in our surveyor, Bill Austin, who explained how he took this mosaic and put it together. And interestingly enough, if you look at all of the deeds, and this is over an extensive period of time where the Smith family was dividing this property, they continually used boundaries that were by definition movable. Arable lands was nothing unique here. They would use terms like cleared land and brush land, meadow land, tilled land, because those were the tools that were available to people at that point in time. They didn't have surveyors going out and doing surveys and creating plans. They used the terms that best described the boundaries that they intended, and that's what they did. And arable lands was no different. It is undisputed in this case that if you take the time, as Bill Austin did, to find that line as it existed in 1841, you can do it. There's no question that you can do it. It is clear that you can do it. And I would suggest that under the Marvell decision, that if you can do that, you have no ambiguities in the deed, and that's really what controls. Now,
just to follow up a little bit, so even the arable land can change if it's the southern boundary is adjacent to the beach, right?
yes, it definitely can change.
And in that circumstance, you would say, you would look back to the original?
You would look back to its location at the time of the grant.
And if the arable land itself has increased through accretion?
Absolutely, Your Honor. That would be the time that you would look at. That's when you look at the intent of the parties. You look to see what did they intend by this deed. Now, keep in mind these deeds, because it's fascinating, the argument that's made. The deed of Pakeway and the beach was from Wilmot to 4 of the 8 years of Samuel Butler. Now, if they were really intending to have a situation where the beach could move up onto the upland without having any impact on title, there was no need to create a separate parcel of land. This was all the same people that were doing this. And curiously, the deed to the beach was only to 4 of the 8 years. Now, you could speculate and maybe infer that the other 4 had no interest in increasing their ownership in the beach because they didn't care about the beach. I can't think of any other explanation as to why it only went to 4 people. Wilmot wasn't retaining any upland at Pakeway, which is sort of the situation that I think is posited in the final concession in the reply brief. He gave it all up. He gave everything up in Pakeway and in the beach. So why did they take the time in 1841, if it was their intention to create a movable beach parcel, why did they create 2 separate parcels of land? They could have just described it as one, and they wouldn't have needed to do that. I think they did it for a purpose. They wanted to create a separate and locatable beach parcel as of 1841. Now, if you look to the next deed of import, the deed to Wilmot from the 8 years of Samuel Smith, you correctly pointed out, Justice Spina, that deed went to a specific boundary, to the fence. And you can't explain that away by pointing to the word or. There was a fence there. They knew it. It was locatable, and it marked the boundary between the newly created beach parcel and the piece that Wilmot was going to get. Think about this from Wilmot's point of view. He's given up his entire interest in Pakeway. He's given up his entire interest in the beach to his nephews. Why would he agree to a deed of an upland parcel, arable land, that he knew was going to go away over time? If it was so clear to everybody that this beach was relicting and that it was moving to the north, why would Wilmot Smith have done that? Why would he have created a parcel for himself, having given up everything else, that is going to go away? There's absolutely nothing in this record to support the pure speculation that that was what these folks intended. And indeed, all of the evidence, if you carefully piece through the deeds and the conveyances, all of the evidence would support a contrary view. Let me just speak briefly about the law. In my view, Judge Trombley did not agree that you could have a movable landward boundary. We all agree that you can have a movable ocean boundary. That's what the law is. There's no question about that. And so if it goes out below the low water mark because of accretion, the landowner owns it, the Commonwealth doesn't, even though it owned it at one time. If it moves back, you lose the benefit of it. There's no question about that. But I don't think that there's a case in Massachusetts that clearly stands for the proposition that the landward boundary does the same. I don't think there is, and Judge Cromley certainly didn't agree with it. And I commend your attention to Brown versus Lightman, an old case admittedly, but very similar factually here. And in that case, the court said, and they noted Scranton versus Brown, which is the big case everybody seems to point to from England.
That's the oyster case, correct?
The oyster case. They said this would create great uncertainty. Their words, great uncertainty, if we were to accept the premise of a movable beach and a landward boundary. I suggest to the court that that's exactly what would be the case here. If this court were to determine that on these facts, and under these specific facts, that you can have a landward northern boundary that can eat up land until it reaches some point in the future, I think that would be a bad precedent. I think it's the precedent that the court rejected 150 years ago, and I think you should do so now. Thank you.
May it please the Court, Peter Pusilowski on behalf of the High Road and Job's Neck Trusts. I'd first just like to direct the Court's attention to our motion to dismiss as to High Road and Short Point. It's unopposed. Those two parties intervened in the suit because of the initial claim by the appellants that they had rights to cross the properties of those two trusts in order to reach the beach. With their concession in their blue brief that they're no longer pressing that argument, those two trusts, or those two entities, no longer have an interest in this appeal, Your Honor. I'd just like to also remind the Court, as Mr. Fleming has conceded, that they have now limited their title argument to the western part of the beach, so that their prayer in the conclusion to their blue brief that the deed to the Job's Neck Trust of a beach interest be voided is no longer operative. Therefore, the only issue I have remaining to address is prescription. And I think the most remarkable part of the appellant's argument is that nowhere in their briefs or here today do they concede the standard for review of a trial court in making findings of fact. As Mr. Hurley pointed out, the judge held a 13-day trial, viewed it, had the opportunity to assess the credibility of the witness, and the standard for review is that those findings will not be reversed unless there's clear error. In this case, there is ample support for the court's findings. And in that case, there being support in the record for them, there's no clear error. In particular, as to permission, I would direct the court to the record references we cite at page 10 and page 35 of our brief. It's perfectly clear that the Flynn's gave permission as to all the property and that the Nortons sought permission as to all the property.
You know, I saw references to Norton family gatherings over a period of decades where they would just go to the beach and spend whole days and weekends. Are you saying every time they sought permission to do that?
No, Your Honor, and I think the best evidence is the concession Alan Norton made, that he loved George Flynn like a father, and that he had given George Flynn the rights to go anywhere on his property, and I think this is a direct quote, just as George Flynn had given me the right to go anywhere on his property. That is ample evidence to support a blanket permission, Your
Your
Honor.
brother says, except the beach, he didn't need to because I owned it.
Well, Your Honor, Judge Trombley was entitled to assess the credibility of the witnesses, and it's clear that he rejected Alan Norton's assertion that I asked permission to go on the property but not the beach.
Wasn't there a statement by someone that Uncle George said that one of the Nortons owned a fifth of the beach or something along those lines?
There is reference by one of the Flynns basically to the Pearlstein opinion. And as Your Honor noted, that opinion is addressed to George and Winthrop at a time when neither of them had any title interest in any of the property at issue here. The opinion was 1950. Both Eliza Norton and Elizabeth Flynn died in 1951. And at that point...
They were remaindermen, right?
Well, Your Honor, as to the Norton property, Eliza Norton owned it outright and left it to Winthrop upon her death. He had no interest at that point in time. As to the Flynn property, also Elizabeth owned it outright and in her will left a life estate to her children and a remainder interest to her grandchildren. But at the time of the opinion, each of the mothers owned the property outright, Your Honor.
Did I read that the Nortons paid taxes on the beach?
Well, Your Honor, that's an interesting issue. Winthrop Norton did not pay taxes from the beginning, Your Honor. He began paying taxes in fiscal year 1979, and I believe the record reflects that he went down and asked to be taxed on the beach. And this is roughly 2 years before his death, when, as Mr. Hurley said, he was worried about estate planning and providing value for his children, Your Honor. He was not taxed continuously on the beach until he asked to be taxed on it. And as Mr. Hurley said, it was around the 1980 period that these assertions as to ownership of the beach came to the fore. My time is up, Your Honor.
Thank you, sir.
Chief Justice Ireland, may I request leave to submit a Rule 16L letter to respond to some of the
Absolutely, and in
points?
fact, I invite all counsel if they choose to.
Thank you very much.